Recording in progress.
Thank you so much for joining us this morning for a webinar discussion from ICJ Kenya. We are grateful to have your participation today. Today we are discussing criminalization of poverty, a driver of injustice. This webinar is convened as part of ICJ Kenya's commemoration of the International Day on Eradication of Poverty, and it's also a build-up to the national and regional campaign on decriminalization of petty offences in Africa. And so the question that we would be asking, we would be answering today, ladies and gentlemen, with the assistance of our panelists, is have our criminal justice systems exacerbated their socio-economic iniquities that we are currently experiencing not only in Kenya but also in Africa at large. So I will straight on go to introducing my panelists. I will begin with Mr. Gitonga Moranga. Mr. Gitonga Moranga is a prosecutor with the Office of the Director of Public Prosecution. He's also a member of the ICJ Kenya Working Group on Criminal Justice and Security Sector Reform. Thank you, Mr. Gitonga Moranga, for your presence today. We have Mr. Donas. He's also an advocate of the High Court of Kenya, a prosecutor with the Office of the Director of Public Prosecution, attached to the Nairobi City Court. Thank you so much, Mr. Donas, for joining us this morning. We also have Mr. Elijah Rotok, also an advocate of the High Court of Kenya, and the Human Rights Officer and Legal Officer at the Kenya National Commission on Human Rights. Thank you, Mr. Elijah, for joining us this morning. We also have Miss Anek Makoti. I hope I am pronouncing your name well. She is also an attorney back in South Africa, and she has done remarkable research and litigation on areas to do with petty offences and criminal justice reform. She's the Executive Director of the Southern Africa Litigation Center based in South Africa. Thank you, Ms. Anek, for joining us this morning. I will also introduce Professor Wanyama. Professor Wanyama, if you could kindly switch on your camera. I think we've lost him. However, he will join as we go by. Professor Wanyama, thank you so much. I can see Professor Wanyama. Professor Wanyama is actually a scholar, a human rights scholar and a law expert. He got his doctorate from the University of Wales in Cardiff. Thank you so much, Professor Wanyama. We are grateful to have you on this panel today. So I will delve directly into the discussions of today, and I will start with Elijah. Elijah, the Kenya National Commission on Human Rights is actually a member of the task force on the National Committee on Criminal Justice Reforms. And it's been, I think, about 2 years down, 2 or 3 years down the line. And I know that the Criminal Justice Reforms Committee is still doing its work. And I know many Kenyans out there are wondering, where are we now in terms of the progress that the committee has made towards reforming the criminal justice system in Kenya?
Thank you very much, Joanne. Thank you for also the panelists and members who have joined in into this webinar. We do appreciate you finding time to be with us. And I would like also to sincerely thank the ICJ for organizing this forum, as it is a timely forum where we can discuss issues related to poverty and the association that comes with crime. I would like to first just state is that I do work for the National Commission on Human Rights, which is the national human rights institution for our country, Kenya. And one of the things that we are keen about is promotion and protection of human rights within all public and private spheres. And our role, of course, is established in the Constitution and also Constitutive Act. Now, to the question about crime and poverty in Kenya, I would like to start by just mentioning that it is a key concern that dignity for all persons who are engaged in all forms of economic activity within our country should be given that space and that full employment and meaningful economic activities within our borders should be protected. And therefore, these persons enjoy rights just as any other. And therefore, we need to relook at how our criminal justice system has been generally approaching the whole aspect of petty offenses within our system. Our work basically, and some of the strategies that we have employed, offenses has affected our country, is that we realize as an agency from the various complaints that we have gotten from various small-scale traders of complaints related to the violation of their rights, such as the right to dignity, harassment, arbitrary arrests, and trumped-up charges by some of the agencies in the process of enforcing some of the laws and the bylaws that we have established within our inspectorates. And from this, it took us to look keenly into some of the structural problems that we do face as a country, and also as county governments, to try and find ways in which we can be more humane and have the rights of any person who is brought before the criminal justice system to enjoy their rights, and also to have that space to not only trade, but also engage in the respect of the rule of law while they're engaging in their trading activities. Now, some of the, I would also like to mention that as a commission, we sit in the coordinating mechanism of the criminal justice sector, that is the National Council on Administration of Justice. And an audit report had been commissioned by the Chief Justice Emeritus, which was to look at the criminal justice system in Kenya, and this was done in association with the Legal Resources Foundation. And one of the outcomes of that report, you realize, is that majority of the offenses that clog within our criminal justice system are petty in nature. And therefore, out of that report, a committee was established that is led by Her Honorable Lady Justice Ngenye, which is known as the National Council on Criminal Justice Reforms. This committee was to spearhead now the put some reforms to look at the criminal justice sector and to see what reforms can be done so as to remove, do away with some of the laws that are not that are clogging our system and are not determinate in nature. And this was quite progressive in the sense that as a continent, the African Commission on Human and People's Rights had come up with principles. And by the time the principles to declassify or reclassify and decriminalize petty offenses in Africa, when they were establishing these principles, Kenya had made steps to look into its justice sector. And this was very key in terms of the progress as a country that we already had some form of systems currently ongoing within our judiciary and also various justice sectors. And one of the terms of references of this committee that is led by Justice Ngenya was to come up with, to review some of the laws, see which laws can be reclassified, and also to come up with better guidelines on how to manage petty offenses within our country. I would also like to mention that it's today and tomorrow, the NCJ would be commemorating 10 years, and they would be launching guidelines officially on how to manage petty offenses. And so these guidelines would now help various actors within the criminal justice and also the county governments in terms of now managing better and having a dignified approach and more so human rights-based approach in how we deal with petty offenses. And in addition to this, we do expect that also some of the laws will be done away with, and you will realize that because of the indeterminate nature and because of the uh, how vague these laws are. Laws such as loitering, you would find that some of the laws such as begging, and you would realize that they do focus primarily on low-income earners from our society, and therefore we needed to relook at some of these offenses in a way that is more humane. And so another category that you will realize is that we do have state regulated offenses within our criminal justice. And in these type of cases, you'll realize that there is no specific complainant, but the state would be trying to regulate some of the offenses that emanate that would be viewed in one way as petty in nature, but because the state wants to regulate some of the economic activities and some of the commercial activities, you'll realize that these offenses would find someone within the criminal justice system, and therefore in a way that they could not be aware, or in such a manner that because the county government might have passed a law that seeks to regulate either some economic activity, then some of the low-income earners would find themselves within the criminal justice. Now, it became a major concern for us as an institution, because you'll realize that in the end, the manner in which some of the arrests and then the processing within even the trial process, you'd realize that the matters would either go on for quite some time, or the kind of fines they do attract would be quite low, such that once the persons are processed and are asked to pay for bail, they would abscond, because the bail terms would more or less be almost equivalent to the ultimate fine if this person is found to be guilty of these offenses. And therefore, you find that within the court process, there's a lot of absconding and failing to meet their bond terms, and therefore orders for forfeiture and such like. Or you would find that because of the nature of these offenses, some of the traders, for instance, hawkers, would find themselves as repeat offenders for quite some time. And also it affected the rights of persons with disabilities and persons who are, and even to some extent, some children where children are also find themselves within the criminal justice system because of offenses that are petty in nature. And so generally, as we look into this issue about the association with some of the offenses that are within our criminal justice system, and the fact that they do target low-income earners and also the poor within our society, then it places us a responsibility on us and as a country to reflect upon the laws that we do have, knowing that some of these laws were borrowed from the colonial governments that had come, and they have been there for quite some time. And the fact that majority of the countries are doing away globally with petty offenses, then Kenya should be at the forefront in terms of relooking its laws towards doing away with any offenses that end up clogging our criminal justice system, and generally put up measures of how to deal with these matters in an administrative way, or using other alternative means or instead of using our criminal justice system. I think again there's a question about cost. Maintaining persons within our prisons is quite costly when you consider the fact that more serious crimes do not end up getting the convictions when you look at that report that had been done to audit our criminal justice system. And therefore, it also places an important role for us to, again, look at where we are prioritizing and where our priorities lie in terms of investigations, in terms of prosecution, and in terms of looking at crimes in Kenya. Are we saying that we should place focus on petty offenses? Because that is a picture that is currently within our country, that our system is clogged with many minor offenses, yet other serious crimes such as sexual offenses and murder are yet to you find that their conviction rates are still quite low when you compare them with petty offenses. So that in general,
Elijah.
is
Thank you so much, Elijah. I find your response quite elaborative. And kindly allow me to then move to Gitonga Moranga from the Office of the Director of Public Prosecutions. Just to pick up from what Elijah has said, tomorrow will actually be a big day because we'll be having the launch of the guidelines on the management of petty offenses, as Elijah has just rightly put. And I would like to pick up from there and maybe ask Advocate Gitonga Moranga, what has the ODPP done towards handling petty offenses?
Thank you so much, John. I hope you can hear clearly.
Yes, I can.
Okay, so as like my colleague has spoken, Elijah, I am aware about the work that we have done under the NCAJ in terms of even coming up with those guidelines. So even when we talk about the progress that has been made in some of these efforts, like the guidelines Mr. Rotok is talking about, ODPP has been quite involved in them, and we have representatives that are in those committees. But as ICJ, you remember, as ODPP, you remember there was a time when the DPP director came in 2018, and he did away or degazetted some of the prosecutors that were there. These were in efforts to ensure that we are able to professionalize prosecutions. And thereafter, we were able to come up with certain policies that are supposed to ensure a professionalized prosecution system such that we are able to apply our discretion in a manner that advances access to justice and is able to allow the prosecutor to utilize his discretion in a manner that is commensurate to advancing the public interest, which also entails not punishing people who are vulnerable or perhaps also poor. Some of these policies include the diversion policy that we have. We have the diversion guidelines. We have also the plea bargaining guidelines that we have put in place, and plea bargaining guidelines. We also have the national prosecution policy that is supposed to guide prosecutors in the ethics and the code of conduct in which they undertake their work and undertake their decisions that they make. All these policies that we have been able to put in place were intended to ensure that prosecutions are done in a very professional manner. And a prosecutor is not supposed to just take a file that comes to his desk and take it to court without giving it the scrutiny or the second eye that it entails. We are supposed to look at the evidence. We are also supposed to look at the public interest aspect of it. You will see that with these policies, there is a great encouragement to prosecutors not to just take all cases to court, But I will throw it back also to the panelists and say that some of these files that come to the prosecutions have been investigated pursuant to members of the public complaining. And if you also look at what Mr. Elijah Rotok was saying, that through the NCAJ and the criminal justice system, they are already quite in advanced stages in making efforts to ensure that there is alternative justice systems that are thriving to allow for petty offenses no longer to be part of the justice system in the way that they are. But we still find members of the community who are adamant that they need to complain on issues that can be resolved at the lower level. So what needs to be done? Do we need to sensitize the members of the public on these issues? What systems do we need to put in place to resolve conflict of a petty nature, so that it doesn't need to resolve itself at the police station? In the absence of these systems or out-of-court systems being equipped, or the public being informed or sensitized about utilizing them, they will keep running to the safety of police stations, and those files will still come to the prosecutions for a decision to be made. So focus should also be on that system or on that process that we can be able to create, so that members of the public no longer find the need to report petty offenses at the police stations, such that it becomes a criminal file. That is my opening statement.
Thank you so much. Thank you so much, Council, for your response. And then that brings me to, I'm wondering, then do we have a problem of a legislating, or do we have a problem of creating regulations for each and every minor offense? Then this brings me to the question, which I would like to address to Professor Wanyama. We find that loitering, which is it's a petty offense, currently people are being arrested for that offense. Can we say, or is it true to say that over-legislating has led to over-policing in Kenya? Professor Wanyama?
Good morning.
Good.
You can hear me finally?
Yes.
Yeah. Though I have a challenge of power like the same way you have in the office, the surge is on and off, but I'll try my best here. Yeah, having listened to your question, it's that it's not a question of legislating from where I sit. It is the issue of what is the priority? What is the priority in our legislations? Is it about realigning the 2010 Constitution, for instance, with the Penal Code and other subsidiary legislations and the county bylaws that some of the councils have spoken about there? And from where I sit, I think we have lost a direction in terms of legislation. We seem not to have a priority in what we legislate. I think we just, every day, every ministry or state department wakes up, they want to come up with a new law because they're unable to solve some minor problems using the existing legislation or the laws here. So that could be one area. And two, also that there's a major disconnect at the moment between the 2010 Constitution, which was meant to be a transformative charter, with the number of the laws and policies that we are coming up with. So there's in itself a problem of the design of the policies or the design of the laws, and there lies a problem that ends up in terms of enforcement and legislation. I think that's my take for at the moment.
Thank you so much for your response. I'll pick up from where the previous panelists have left, and maybe just pose a question to Anek. can we say that our criminal justice systems have become key drivers of injustice?
Yes, I would like to reiterate, I think, what my colleagues on the panel have said. I think our criminal justice system has always been a driver of injustice. In fact, that's how it was set up initially, as a form of social control and part of the colonial project. So whether it's our policing services or our penal system or the penal code itself, it was conceptualized with unjust purpose behind it. So what we're doing now, and I can see that, and Kenya is far more advanced than many other countries in terms of trying to develop guidelines and reforms to actually ensure that it transforms its system and its criminal justice system to something that is more just. But I do still feel like it's as if we're still starting from the original premise. And that's perhaps what Prof. Wanyama, perhaps to link up with what he's been saying, is that in a sense, and this is the same problem all over, is that you have a constitutional framework which is transformative or intends to be transformative, and then you have a criminal justice system, whether it's the institution or the laws that surround that institution, that dates back to the colonial era, and it almost requires an entire rethink, because, and it brings me back, I think, to the point that Mr. Muranga was making about the community running to the police. So what we do is the link between the crimes that we have and the crimes that ends up being reported is often related. So we sort of, the community is enabled to run to the police because we have these sort of vague offenses like common nuisance and breach of peace, and they think, oh, it's a breach of peace, I'm going to go complain at the police station. And then you start thinking, so what would then the role of the police be? Is it their role to just take every complaint that comes to them and push it off to the prosecutor, and then the prosecutor have to decide what to do with it? Or should the police also have a conflict resolution and educative approach to these sort of things, so that it actually educates the community at the same time to say, no, but this is not police business. What you're talking about is your neighbor annoying you. That's part of life. Move if you don't like it, type of thing. Or perhaps go talk to your neighbor or speak to someone else, but it's not a criminal offense. You know, like, at which point do we start actually changing mindsets of the community, of the magistrates, of the police officers, to say that what annoys you is not necessarily a criminal offense, and not everything can be criminalized, because the impact of that criminalization is simply too unjust and too disproportionate a response. So someone makes a noise and you arrest them. That is too disproportionate a response, the arrest, to what the actual offense or so-called offense would have been. And as a result of that, and because of poverty, we then find that many people get lost within the criminal justice system because they're not able to call a lawyer to get them out when they have been arrested for something really silly. So there's been instances where people would have committed really petty offenses, but they would have been incarcerated in custody, awaiting on pretrial detention for up to a year. We have people at Matari Mental Hospital who were arrested for trespassing, and they have intellectual and psychosocial disabilities. And in one instance, the person was arrested for trespassing, and they've been at Matari Hospital for 4,000 days without any charge. The police simply took them there. So what we have is a criminal justice system that perpetuates the notion of control, the notion of locking up and arresting people we don't, people we judge or people we feel are not of equal value in our society. And a lot of that goes back to discrimination, which is, and this is something that's come out throughout Africa, that as societies, we discriminate against people more than anything else based on their economic status. So as much as the Constitution is transformative, we haven't changed our mindset to actually recognize that if the criminal justice system was built to dehumanize and people. How do we take that out of that and actually recognize the dignity of each and every person, and then look at how we transform the criminal justice system? I'll leave it at that, Joanne. Thank you.
Thank you so much, Annette, for your response. And then that brings me to the question on, since we the petty offenders are still going through the criminal justice system in Kenya, then what would then be what are the evidentiary challenges that are associated with prosecuting petty offenses in Kenya? This is a question to Donis Ongira, who's a Nairobi City Court prosecutor. Welcome, Donis.
Thank you very much. The first thing when it comes to the evidentiary, the evidence considered in terms of prosecuting petty offences is the unavailability of witnesses in the first place to can appear. To come to court, to give evidence in this kind of cases. Reason being that in most instances, it's always an offence that is enforced by, say, the county government or the government per se. So getting eyewitnesses who actually come and confirm that these incidents actually occur, number one, is a relevant issue. And then number two, there's just the lack of awareness of individuals that there is the existence of offences of this nature. What I've gathered is that most of these petty offenders are not really afraid of the fact that what they're actually doing is an offense, but rather the fact that they can actually be arrested by the enforcers. So they'd rather run away from the enforcers, than commit the offense. But at the end of the day, what they're looking for is a means to an end. So for me, I think first issue is criminalizing petty offences. Number one, opens an avenue for corruption in the first instance, because number one, witnesses don't come. The moment those cases stay for longer in court, the more you give those cases an opportunity for people to do whatever it is they do behind locked doors, and that then, of course, then creates a little effect over then what the court is expected to do in terms of even coming those cases. So you'll find that in most circumstances, these cases do come to court, but at the end of the day, you'll find that they are also withdrawn for reasons that either witnesses do not appear in court to give evidence, or that the evidence that they have collected. For instance, let me just give an example, for instance. Individuals who are perhaps apprehended, these are probably vegetable vendors or food vendors who are apprehended. First thing we know for a fact is that these are basically traceable products. So ordinarily, you don't expect them to stay for so long. But the way our justice system has been, our court system rather, the way our court systems have been modeled around is the fact that the procedure of trial is such a long process that by the time that this evidence, for instance, is supposed to be tendered to court to go, as evidence, that's about 6 months down the line. I mean, what are you going to do with a banana that that was already ripe and has been is now there as evidence? Those are not the challenges that the system actually has, and I believe there is a need to accept that. Number one, to combat the aspect of corruption, and number two, for the mere fact that you cannot and you should not criminalize a poverty in any way. What the government will do is actually put up systems to address this particular issue without necessarily criminalizing them in any way whatsoever. That relates to respect to evidence that comes to court, availability of witnesses, number one, and just the period that the court takes to come with such kind of cases, and what then the court does in terms of particular cases. Some cases, like yesterday, as I was in court, for instance, it kind of feels like most of the enforcers, the county government enforcers, have lost that human touch. And there is need to also professionalize that particular unit, or to second the police to that particular unit. Even being that the gentleman who had actually been arrested, and unfortunately he was begging, and he didn't have any arms on him. This guy, he didn't have his limit. And when he actually was brought before court, I was surprised because the people who are actually angry at the fact that a person who has a disability has been brought before court are the colleagues of the enforcers. So there's that disconnect because there's that disconnect between being humane and enforcing the law in terms of dealing with safety offenses. That's my take about now.
Thank you so much, Mr. How many cases the Nairobi City Court processes in terms of how many petty offenses cases are brought before the Nairobi City Court on a daily basis, or roughly a month? How many cases do you prosecute as a prosecutor?
Well, I'll admit that I have been to Nairobi City Court for the past 2 weeks. I just got transferred there. And how the office has demystified the two is that what I realized is that there are county prosecutors who ordinarily handle those particular matters, and then there are from also the DPP who then handle matters under the penal code. But what I can tell you for a fact is that I get to the office at about 7:15. At 7:15, there's a parade. This is just to give you an enlightenment of what perhaps happened. But around between 7:15 there about 8:45, there's a parade that is carried forward, I believe, by now the county government, directing them to enforce the law and do whatever it is they need to do in terms of enforcing the bylaw. Now, from 8 to around 11, different motor vehicles streaming with not less than about 15 people, I could say about 3, 4, 5, 6, bringing them to court. So on average, I would say not less than 100 people in a day are processed with respect to safety offenses at the city court. Not less than 100 people.
Not less than 100 people.
That is nothing.
Not less than 100 petty offenders going through the criminal justice system in a day. That's quite a huge number. And then, so that brings me to my other question to Miss Anek. Looking at just what, and for picking up from what Donex Ongira has said, so how do we bridge the gap between the ideals and the aspirations and implementation? Because there's a lot that's being done at the policy and the legislative level, both at the regional and the national level. However, these things seem not to trickle down to the domestic level. So how do we bridge the gap between ideals and between aspirations and realities?
That's a hard question, but okay. It starts with having a human rights approach to everything that we do. But I think what worries me is that you have sort of your criminal justice system, which, horrible as it is, has some sort of in theory, procedural guidelines to prevent abuse. Obviously, the abuse still happens. And then what we have allowed is that we've allowed, at municipal or county level, we've allowed a second level of enforcement, which is much harder to ensure that they actually comply with human rights standards and with procedural guidelines. And that's for me and this is what was mentioned earlier by Mr. Muranga about the community as well, because now if you have communities at county level wanting certain types of behavior to be addressed, then what you have is you have officers and askaris who are too gung-ho in sort of wanting to support citizens and enforce citizens' wishes. And when they do so very much in a manner that is blind to human rights, in a manner that dehumanizes people, and in a manner that specifically targets people with disabilities, people who are trying to engage in economic activities on the streets, children who live and work on the streets, persons who beg, persons who are gender non-conforming, sex workers. So all these people who are genuinely just trying to survive in public spaces because they are deemed a nuisance to people in nice houses close to the public space or whatever else. Now there's this askaris who would just come and do whatever they want to do. And that for me is that's where we cannot allow too much power in the hands of people who have not been trained to wield that power with discretion and in a humane way. And we cannot allow power to, or give power to people where there isn't sufficient oversight mechanisms in place. And that's for me, I think, key. If we can figure out a way to ensure that there's oversight, so it's not that police officers or askaris arrest people and then the prosecutors might decline not to prosecute. That's one level of oversight, which is a very important one. But at that point, the person has already been dehumanized by the arrest itself. They've been traumatized by the arrest itself. So how do you prevent even the arrest? So when there's operations to, or big sort of operations like cleaning the streets or something like that, especially in those instances where we see the bulk of human rights abuses, the bulk of bribery and those sort of things happening in those instances, and especially at night, we need to ensure that there are semi-independent people who have an oversight over those activities and can step in and say, hey, hold on, you're not doing this correctly, you're not responding in a way that is unbiased and those sort of things. Because at the moment, I don't think we can trust the police and the askaris to police themselves. And that's for me where we need to start. And if we start changing the culture within our law enforcement agencies, that change in culture will then mean that there's less enforcement of petty offences, and some of the petty offences will then fall away also, and be part of the law reform process. I don't know if that answered your question, but it was a very hard question. So I'll leave it there.
Thank you so much, Anek. I must, you might think it's a hard question, but I think you've answered it pretty well. And I like the insights that you've given, and I would want to pick up from there and ask Elijah. We have and also in your introductory remarks, you referred to the principles on decriminalization and reclassification of petty offences in Africa. How do you think we can strengthen state commitment or observance or adherence to these principles? What are some of the strategies or approaches that should be undertaken to ensure that states actually commit and follow up on their obligations as stipulated under these principles? Thank you. Over to you, Elijah.
Thank you, Joanne, for that important question. What we'd like to point out is that our institution advises the state in terms of its compliance to international instruments, and the fact that we are an advisory agency on matters human rights gives us an obligation to consider and relook at the commitments in which our country has ratified and committed to implement. And therefore compare whatever has been committed to and what is on the ground in terms of juxtaposing policy and then practice, and then provide now the advisory under which the state needs to make measures. And one of the avenues that I would like to truly appreciate is the annual conference in which ICJ and together with various stakeholders within the NCAJ hold, where the conference specifically targeting petty offenses, where many actors and also members of the public get to engage in, is one of the avenues in which all stakeholders come together and then try and take stock of the progress and what ought to be done towards now realizing this. Now, to the African principles, you would, we as a country sort of in that advantage position, because just before, while the process of coming up with these principles towards decriminalizing and also reclassifying petty offenses happened, Kenya at that time had initiated the audit of its criminal justice system, and therefore, and then that committee had also already been established. So to that extent, we had that sort of advantage where other African countries would come to look at what Kenya has done progressively and then also try and implement the same. Now, towards realizing these commitments that we have done as a country and also as African countries in general, is to look at what these policies mean, and you will realize that the principles are directly drawn from the already existing African Commission on African Principles on Human and People's Rights, especially on the right to dignity, right to equality before the law, and also the right to fair and administrative action, especially when any person engages with any state agency. And when you look at when you look at the principles, you will realize that as a country, with the fact that we have already begun the process of not only developing guidelines to actualize these principles, but also look at some of the laws specifically, and that are especially of nuisance, that are indeterminate, and that go towards targeting low-income earners and also the poor within our country. I would just like to mention some of the offenses that we really need to start thinking and relooking at. Offenses such as breaches of peace, threatening common nuisance, being idle and disorderly, and also or drunk and disorderly. And then when you look at some of the bylaws that are existent, especially within our major cities such as Mombasa, Nairobi, and Kisumu, or even within the county governments, you'll realize that the city inspectorates would still enforce laws such as loitering in public places for immoral purposes, nuisance by public urination, either using a public toilet without failing to pay the amount to use, or even hawking, vending, common nuisance and indecencies are just a few that these matters could be addressed administratively, not necessarily require the police to enforce this by subjecting the would-be offenders or the would-be people who would create that common nuisance by subjecting them through the entire criminal justice. And what's one of the another way of trying to actualize the principles is by now creating that awareness. And one of the advantages that we have seen, or strategies that we have tried and has worked considerably well, is using the court users committees and showing them the principles, and not only the principles, but also sharing with them some of the decisions that have come up within our African system, such as the Palu case that specifically looked at all vagrancy laws in Africa, and the advisory opinion that came from that establishment. And you would realize that the police within that, with the court users committee, the prosecutors, and also the magistrates and the probation officers, the children officers, and all the actors that form a part and parcel of the court users committees, have you realize that they do accept that the nature and the circumstances in which our criminal justice system is functioning sort of leans towards now targeting the poor. You would find, for instance, children within the YCTC centers on charges such as preparation to commit a felony. And then when you look at the ingredients and the facts that are surrounding, or when you look at the matters, they are sort of indeterminate and they do not meet this. And when these children try to exercise their appeal processes, you'd find that most of these offenses would either drop off, or by the time a child has gone through that process and then they are acquitted, they would have spent 2 or 3 years, and because they are not able to raise the bail terms, they end up staying within the holding facilities for quite a number of days. And in addition also to this is that similarly, at the advent of the COVID-19 pandemic and the enforcement of the health guidelines that had been set up by the Ministry of Health, you'd realize that the offense of failing, especially of failing to wear a mask, and also the offense of breaching the curfew, ended up having a lot of mass arrests and also processing within the criminal justice, to the extent that I remember the Council on Administration of Justice had issued some guidelines to require that all petty offenses were to be addressed at the station, so as to avoid the clogging, and also to avoid the processing of these matters before court, and also to limit the incarceration or the placing of offenders within our prison holding facilities. And you would see that some courts were quite progressive in the sense that where they were able to see that an offender is not able to raise the bail terms, they were quick and are willing to exercise their discretion to lower this, to lower the bail terms, and or even issue out free bond for some of the offenses. And this was progressive, and the fact that you would see that the courts were moving towards unclogging the system by releasing some of these minor offenders so as to help them continue with their lives. Now, another strategy is also that I would like to commend, for instance, the office of the DPP, is when they came up with the diversionary guidelines. And especially, I remember seeing a circular, particularly on the offense of touting. This event had gone way beyond the practice, in the sense that you would find a considerable number of young people were being criminal justice through this offense of touting. And when the DPP issued a direction that these matters and that should not be prosecuted and other alternative means should be used, you would that gave a positive approach, and also towards the justice actors, and the police were able to use other means of trying to regulate public conduct and order and management. And so another, some of the strategies is now how do we have all the actors participate towards in a way that they would first remove more people from prisons. And you also remember how the judiciary participated in looking at reviewing of the offenses, and they were specifically targeting petty offenses so as to try and declutter and reduce the congestion within our prisons. And you will agree that the status of our prisons and generally in Africa are not, are still yet to get to that standard, especially under the Mandela rules. And because of the congestion that exhibits the living conditions of each infringing further the rights of persons who are deprived of liberty or who are already within our prison systems. And so that move by the judiciary to now review cases went a long way, not only in addressing congestion, but also helping towards reducing the COVID-19 infections within our prison facilities. And so I am very much hopeful that while we engage as actors and with the launch of these guidelines to manage the petty offenders within our laws and within our criminal justice sector, it would go a long way in terms of realizing the rights of many Kenyans and also having to deal with some of the problems within our society by using other means such as the promotion of economic and social cultural rights, where instead of providing, using the criminal justice to punish some of the minor offenses, these offenses can be done away with by use of other programs that would uplift the living standards of our people so that we have a better society that is more humane and that is respective of human rights for all. That is my statement as of now. Thank you.
Thank you so much, Elijah. I'd like to pick up from your insights and maybe just pose a question to Council Moranga, and also pick up from what Donis just shared with us. The ODPP has actually done a commendable work in terms of releasing petty offenders. This was even prior to the COVID-19 pandemic. We had more than 500 petty offenders being released countrywide. So my question is, while the ODPP is taking or making efforts towards releasing petty offenders from the from prisons, we're still having 100 cases of petty offenders being processed within the criminal justice system. Do you think there's still more that needs to be done in order for us to realize the decriminalization of petty offenses in practice? And what is that needs to be done? Over to you, Council Moranga.
Thank you, John. Rightly, as you have said, there's a lot that has been done within the criminal justice system in terms of policies and frameworks, but we're still finding that these cases are coming. I just like Rotok was saying, other than the judiciary doing its own review of cases, the ODPP itself has undertaken continuous review of cases that we find with remandees when we go to prisons, prison visits. When we are able to see remandees are in custody for a while, we're able to look at their cases and to see which ones that are still pending. And you will see that this is part of the conversation that is also ongoing at the NCAJ level to perhaps have a bail and bond bill. But I will say it's not all gloom, because you find, even from our study that we did in 2018, All for Justice program, that there's been a decline in the number of petty offenders that are still in remand. You'll find that the ones that were in remand before because of committing petty offenses have since left the remand sector. They are no longer being held in prisons as it were before. That number has declined significantly, and that is subject also to the fact that the courts have been willingly giving bail and bond to some of these offenses. But you find largely that despite the decline in these petty offenses in prisons, the people who are being held in those remands are poor. They are poor because they're the ones who are likely to commit the heinous offenses as well. The murder, the violent crimes, you'll find that the ones who are committing it, and they are unable to raise the bail or bond that they have been given in order to be out, which means that we can't really escape as well the aspect of the community sensitization aspect. Remember that these persons who are in remand are part of a community, and if the community is unable to take charge or take ownership of a particular person who's in remand, it also means that progressively we are moving towards an individualized society, whereby everybody is going to carry their own cross, or everybody is carrying their own cross. So these people who are in prison are unable to get their communities, for instance, to hold bond for them, or to hold surety for them. And even when the court continues to lower the bond or the bail terms, they are still unable to leave the system. And where they have committed, they have been convicted to a fine, they are unable to pay the fine despite progressively it being reduced or leniency being given, because some of them are willing to pursue the whole, to go through the whole conviction period, as opposed, a sentence period, as opposed to paying the fine that they have been granted. But you also see that as we are still encouraging as the ODPP for many of the people who are still being held or suspects being held in remand to undertake plea bargaining and to have their cases quickly resolved, many of them are unable to perhaps still understand the process, and that's why we continue undertaking sensitizations of remandees on why it is important to take plea bargaining. But you also must understand that there is a small influence that needs to be undertaken in the plea bargaining process for the prosecutor. When we discuss with the accused person and we say, okay, plead guilty for this and this offense, and we will persuade the court to have your sentence reduced. But you find that our system, that the sentence is the sole prerogative of the courts, which means that there is a possibility the court may not agree with us, which of course further complicates these issues, so that if the prosecutor is able to advise the accused person to plea bargain and lower their sentence, there is no guarantee that the courts will be able to pass the sentence that the prosecutor has recommended. It's a double-edged sword. It's something that requires more discussion. But you can also see the challenge that we are facing as a country. The country unable to have adequate resources to be able to support the systems that will allow the petty offenses not to be punishing in the way that it is. In this sense, the legal aid scheme is still unable to take off as it should be. We are unable to do that because of lack of adequate funding. If that system is supported, perhaps you'll be able to find people who are taken to court for petty offenses adequately advised, legally, and also represented. But you find that although we've been taking reforms in the criminal justice of the judiciary, the ODPP's office, there is still not enough that has been done in the inspectorates. That's why you're seeing 100 cases still coming in, because although we have been doing the sensitization at the prosecution's office, the inspectorates are still operating, as Anek had said, in a parallel system. And And although we have the policies that we've put in place are supposed to apply to prosecutors of any office, as long as you're applying yourself to prosecution powers, you're supposed to adhere to the policies that the ODP has put in place. You're still finding many of them are still unable to adhere to them or comply with the policies that are put in place. It means there is work to be done at the inspectorate levels. There is work to be done at the community level, but not to say that nothing has been done. We know that the judiciary and the ODPP and other sectors have gone out to the communities to try as much as possible to sensitize on these processes and give the communities an indication of alternative justice systems that are available. But I will also return it back to the panelists and ask, if we say that criminalizing petty offenses is wrong, or that we should be able to undertake alternative justice system, which I do agree with, what systems are we going to put in place to prevent that community member taking justice into his own hands, to prevent them getting frustrated with the justice system, that it's not responding to their complaints, and to take it to themselves and maybe harm their neighbor, and then create another ripple effect that we are unable to sustain. So that's where I think we should be able to focus on the community and mechanisms to be able to address petty offenses and complaints among citizens. And I think a good starting point would be the establishment of the small claims court, which will allow perhaps certain kind of petty issues to be resolved in a civil manner in that court. And that gives an avenue to some of the grievances to be addressed in that level. But for many others, and I'll ask maybe if Rotok will get a chance, for instance, in the case where you're having traders putting their merchandise in front of a merchandiser who has paid rent and is in his premises, but there's someone else who's put his merchandise outside, he's put his wares outside for selling. It means the person who's paying rent is also disenfranchised by the person who has put his merchandise at the front of the shop, unable to attract the customers he wants, which takes his revenue down. There is also the aspect of the pedestrians whose paths are blocked by the merchandiser who's put his wares at the front. How do we address this? How do we deal with this kind of petty menace, and how are we able to address it? And for me, I see a starting point again will be to have community-based or business-based solutions, whereby we get these people who are street merchants or people selling merchandise in the streets are able to be approached and asked or sensitized on better ways in which they can be able to sell the merchandise, and participate or ask them where else they would prefer selling their merchandise, and the importance of perhaps having a self-regulated mechanism in which they can be able to sell their merchandise, and not also undertake projects like creating markets in places that they do not find favorable. So that's my closing remarks. Thanks.
Thank you so much. Your remarks have actually got me thinking. Recently, we've seen news articles going around that hawkers are being sort of restricted from accessing a certain area because they are considered to be quite unappealing. So then this brings me to my next question to Professor Wanyama. In terms of our criminal justice systems, are we providing criminal justice system responses to address socio-economic issues? Professor Wanyama.
You can hear me? Hello?
Hello, yes, I can hear you.
Am I there? I have this challenge. Just come again with your question. You'll bear with me.
Yes, and I'm just saying that you find that in many African countries, the informal sector actually equates for a huge number of a huge number of people make a living from the informal sector, and they meet their needs by working in the informal sector. However, we find that, for instance, recently there's an article that has been going around that hawkers have been restricted to access a certain area because they are considered to be quite unappealing. And then there's the issue of hawkers touting. I mean, there's the issue of loitering, there's the issue of touting. And so my question is, is it proper to say that we're giving criminal justice response, we're using criminal justice responses to address socio-economic challenges?
Yes, I hope you can hear me now this time.
Yes.
If you're able to hear me,
really,
you are correct. If your question is correct in that sense that instead of providing, coming up with the policies, both socioeconomic and development policies that address the issue of livelihoods, we are using the same, as I said, the penal code and the criminal justice system at large, which has a lot of the colonial relic in it, to kind of just keep on criminalizing people who want to earn a livelihood, because they are not the policies and the plans, the socioeconomic policies and the development policies do not really address the issue of the people who are not in the mainstream economy. And that's a big problem. I would say that. That is correct to say that. And having said that, maybe you'll allow me to say a little bit more about that, to say the Kenya specific area. That in Kenya, we have there is a major problem in terms of how designed say that we are still relying on the old colonial relic, laws and bylaws to punish to punish who are not in the mainstream economy, which is sad. Looking at this economy that show that which is sad. Show that 70% of economy that show that which is our revenue comes from the informal sector. Which is our revenue comes from the informal sector. Which is our revenue comes from the informal sector.
Onyema, thank you so much for your response. I think I'll pick from there and maybe just go direct to donors. And donors, Council donors. My question to you is, we all know that around August, there was the Public Nuisance Act that was signed into law by Her Excellency, the Acting Governor of Nairobi County. So my question is, do you think, in your opinion, does the Public Nuisance Act have the potential of reintroducing petty offences into the criminal justice system? The Public Nuisance Act was signed into law about 2 months ago by Her Excellency the Acting Governor of Nairobi County, Anne Kananu. So in your opinion, and having prosecuted petty offences at the Nairobi City Court, does this act provide a leeway through which petty offences are being reintroduced to the criminal justice system?
If I would answer that genuinely, yes, that would reintroduce criminalization of petty offences back into the system, and we can't run away from the fact that it does. Unfortunately, we need. It's my opinion that we need, sorry to say, but some sort of progressive leadership, such that then we don't have one arm of of an institution doing something, and then another arm of the government reintroduces that particular subject. So by all means, that particular act will reintroduce criminalization of petty offenses within Nairobi County.
Thank you so much. And kindly allow me to just pick up on that conversation and the information that we've received about the number of petty offenses that are actually being processed in the city court on a daily basis. And pose a question to Council Gitonga. So we have a question from one of our participants, and the question is directed to the ODPP. There's a question of what is the well-being of the bench and the prosecutors if you have more than 100 persons being brought to one court a day, as the prosecutor has said of the city court. How does one expect less than 80 magistrates and prosecutors who also have ongoing matters to manage that caseload? Council Gitonga.
My apologies, John. Maybe you can repeat the question.
We've received a question. This is a concern about the well-being of the magistrates and the prosecutors who have to, on a daily basis, deal with 100 cases where there's actually an issue of capacity. So what is the well-being, what measures are being taken to cater for the well-being of prosecutors and magistrates who are handling a huge number of cases on one day?
Thank you so much for that question. As you are aware, the Parliament allowed the office to continue making effort to hire and increase the number of prosecutors within its rank and file. That process is still ongoing, and we have continued to increase our numbers from where they were 4 or 5 years ago. We've increased them tenfold. At the moment you could count, we have about 900 plus prosecutors in the country. So we continue to add on to those numbers and be able to increase this capacity. But as we had said earlier, the whole purpose of also is in the policies that we're able to launch. That's the diversion policy and the plea bargaining guidelines and diversion guidelines as well. All these processes are supposed to ensure we decongest the system so that prosecutors no longer have to handle a lot of a long cost list in terms of cases that come before them. And also the decision to charge. Remember, the decision to charge guidelines is also a tool that is used by prosecutors to ensure that not all cases get to the criminal justice system. The decision to charge process will enable the prosecutor to not allow cases that have either insufficient evidence or are not supposed to be in the criminal justice system to pass through to go to be before the magistrate. So at that level of screening, that's the level that we are utilizing to ensure that the number of cases that are registered are not just the police station, either to gather more evidence or to pursue other alternative means of resolution. That is where we are going as an office, and that's what we intend. We do not intend to clog the system with just any type of cases that are supposed to that are brought to our attention. And as I said, one of the things that we have to do is also do community sensitization to inform them that we are not reneging on our obligations, but that we are using set guidelines and procedures to prevent certain cases to come into the systems for their own good, for the whole community's good, so that they're able to resolve some of these cases that have an impact on the system and also on the economic aspect of the country. Because remember, criminal cases are costly. and all this comes to affect each one of us one way or another. That is my feedback.
Thank you so much. Thank you so much. This brings me now to there have been a number of gains that have been made at the regional and the national level in terms of advancing or calling for the need for states to decriminalize petty offences. So this is a question I'd like to direct to Anek. There was a decision that was rendered by the African Court on the compatibility of the vagrancy laws in line with looking at the provision set out under the African Charter. So Anek, these are developments that actually taking place at the regional level. And this is actually a significant decision that could be utilized at the domestic level. So in your opinion, how do we strengthen judicial responses to petty offenses?
Thank you. Yes, in December last year, the African Court gave an advisory opinion specifically looking at the type of laws we were discussing today, loitering, those sort of laws which actually try and penalize people who are basically using public spaces. And the African Commission was quite clear about it in many different ways. So for one, sometimes the way in which these laws are formulated already tells you that it's treating certain people in a derogatory and a dehumanizing way. And as such, it violates the African Charter. So if you look, for example, at the idle and disorderly offenses in Kenya, it says you're idle and disorderly person, but that's a very loaded term to start off with. Also a very vague term, so anyone could really fall under that. And that was the other issue by the African Court about offences are too vague. And if you look at a number of offences, for example, in the penal code in Kenya, for my colleagues mentioned breach of peace, for example, or common nuisance, or idle and disorderly. So all these offences are so broadly worded that no one really knows what it falls under. So although case law would have said that breach of peace only really applies in the case where there's an actual threat or fear of some sort of harm coming or actual harm being perpetrated, that's not how it gets enforced in practice. Idle and disorderly offences are, and there's been case law in Kenya on how these offences are enforced in a way that don't actually even comply with the offence itself. Offences like disobeying lawful orders, all these sort of offences, it might sound okay, but if you interrogate it, you realize that actually they're so broad that the ordinary person wouldn't actually know what is criminalized and what is not criminalized, which then means that someone is arrested for something they didn't know they were doing wrong. It also means that the police assume that people are criminals by the way in which they look or the way in which they behave, which then means it violates the presumption of innocence. So there's a whole number of laws that simply on their face and in how they are being enforced violate the rights in the African Charter and the rights in Kenya's constitution. And on this basis, the African Court told all African states, reform your laws urgently. Take urgent measures to reform your laws. And in the meantime, those laws that it's clear to everyone that they're unconstitutional, such as the idle and disorderly laws, while you're reforming your laws, stop enforcing offences which clearly discriminate against the poor and the marginalized within our society. So I think just my last point, the African Court was very clear that we cannot discriminate against people based on economic status. In fact, this was quite important judgment because there's not many judgments which recognize discrimination based on economic status. And then, if we realize that you can't discriminate against people based on economic status, why not actually speak to people and try and have them themselves regulate their their business that they're in. As Mr. Morango was saying, I think we would, we're not recognizing people if we're not providing them with the opportunity to self-organize. And there's been many instances throughout Africa where initiatives to actually allow self-regulation has worked out well and has improved the relationship between communities and, for example, street vendors or sex workers or any sort of other groups that traditionally are not recognized. So I think what we need to do is we need to take the leap, and instead of governments making the law, let's put some of that regulation back into the communities and have them come up with creative solutions to the problems they face.
Thank you. Thank you so much, Anek. Thank you so much. And as we wind up on this discussion, I will then invite our panelists, each of our panelists, to give their closing remarks, starting from Mr. Talk.
Thank you, Joanne. My closing address the question about Hello, I hope you can hear me now.
Elijah. My closing remarks is that the whole question about petty offenses cannot be addressed by one agency, and hence the need for more collaboration, especially from the justice actors, and also to have more public participation on this important question. And even when coming up with any bylaws that guide especially our city inspectorates and our county governments, that the inclusion of public participation and the adherence to human rights-based principles, especially on equality before the law and discrimination, the right to dignity and the promotion of and the protection of rights to women, children, and the elderly persons, including persons with disabilities, and also the need to have all our laws comply with human rights standards is critical, so as to have laws that are reflective of not only our cultural aspects and practices within the country, but protect the vulnerable within our communities and within our areas that these laws are applicable. And therefore it calls upon all the justice actors to look at our laws especially and try and take from where the positions that we do hold, to use them as positions of influence so as to inspire change towards actualizing and realizing the decriminalization of poverty within our country. And therefore, in our strategies, in our various positions that we do hold, it is critical that we use these avenues to promote and protect the rights of Kenyans, and also the charters that we have all assigned to, ratified, and also domesticated in our laws. We will continue to provide advisory positions to various state agencies and also the private sector towards actualizing this, and we will also continue to lobby and provide advocacy towards the moving from policy to practice, especially at the ground level where we have various actors who need to
be sensitized on this and also to adopt these approaches. And the fact that this requires an inclusive approach where also not only members of the public are to be engaged, but even all the actors, wherever they are in our respective agencies, need to adopt this and to have the actual buy-in, so that as we progress towards decriminalization, and we have policies and laws that are responsive to us. Thank you very much for the opportunity that we've been given, and we'd like to look forward to engaging more in this, especially as actors, and also to take stock of the progress when we yet meet again and to deliberate on the same matter. Thank you very much, Joanne and team and panelists.
Thank you so much, Elijah. Kindly allow me to go to Miss Anek.
Hi, thanks, Joanne. I'll be very brief. It's always an interesting discussion. ICJ Kenya hosts the website of the regional campaign to decriminalize petty offences. I've put the website in the chat box. I would encourage all my panelists and the attendees, if you have documents relating to petty offences, send it to ICJ Kenya for it to be uploaded onto the website, because Kenya has made such great advancements in terms of its sentencing guidelines and the guidelines that will be released tomorrow and those sort of things. And by sharing it on the website, it can actually inspire colleagues throughout Africa. So I would just invite you to share and to be part of the campaign. Thank you.
Thank you so much, Anek. Kindly allow me to invite Council Gitonga.
Thank you, John, for this opportunity. First, ask the question, so what next? That's what I think we need to address, because the issue of decriminalization of petty offenses and reclassification of offenses, that's a train that has already left the station. There is no doubt in my mind that a lot of action is going to take place in this aspect. The judiciary is highly on board, and NCAJ actors, including ODPP, the main stakeholders in the criminal justice system, are all on board. The government stakeholders or agencies that have been tasked to deal with these issues are on board, including Elijah Rotok. So we are saying, as you can easily see, that there is effort towards decriminalizing of petty offenses. But so what next? Who takes over the aspect that we were speaking about creating mechanisms in which we can have people, merchandise vendors, self-regulate, and we can have places that are still stuck with colonial relics, like the inspectorate departments of the counties. How do we get them to speed up and join and get to the level of other justice actors who have already tried to remove the clock of colonialism from their management or from their way of doing things? How do we get them on board? How do we get the street vendors on board to understand also what is going on and what needs to be done, so that there is a cohesive community in which we live in, so that we all buy in the project of being Ubuntu, or living together in a way that petty issues or petty offenses are no longer part of issues we take to court. There's a lot that needs to be done, although we've already done a lot in the policy level. But I think more conversations are needed, and the public needs to be engaged a bit more on these issues. That's my closing statement.
So much, Council Moranga. Thank you. Thank you so much, Council Moranga. I like the so what next.
to address this particular issue. Is it enough? Well, time will tell. But much as that, much as I've said that, I believe all of us need to play our role to basically discharge our mandate and decriminalize petty offenses. That's all I can say for now.
Thank you so much, Council. Thank you so much, Council, and we acknowledge the fact that you actually set aside time to join this panel, and you had a hearing session, so we are really grateful for the insights and information that you have shared with us today. Can you allow me to then invite Professor Wanyama, if you're still on?
Okay, you can join. Okay,
I'm very sorry for I'm trying my best, but I don't know. Joan, can you hear me?
I can hear you.
There's a big echo, but I'll try and say just a few points that from this discussion, we're able, it's actually a confirmation of one of the Frederick Angel's writing, which says in Das Kapital says that people who have no power and resources have no control over their lives. And therefore, they end up being criminalized, as this topic we've been discussing about. And just two quick things before I'm cut off again, is that there is a really need for the government of Kenya to rework all the economic and social policies that are being implemented in this country. They are actually the ones which are the root cause that end up into petty offense. We have people ending up into being criminalized through those the small petty offenses that they commit. That's very important, that there's a need really to come up with the inclusive policies in the socio-economic as far as the sustainable development is concerned. And once that is done and they're being implemented, they will have a really correlation with the way the criminal justice system operates. And now, which also brings it to the other area, which that two, the penal code also needs to be reviewed and amended in line with the new constitutional dispensation. I have read it many times and given recommendations to members of parliament, in that really we have even things which are still 1936 provisions which are still contained in the penal code. So that cannot really be the way to go about it. And then the other point, which is important, that Council Donek pointed to it, which I want to end with, is that the policy reforms, they are also very key in the sense that under the new constitutional dispensation, the police are meant to transform from being a force to a service. But that has not happened. The mindset, the attitude of the police is still the one of the force. So also that needs to be addressed. And then the final one is that we also have Chapter 15 constitutional commissions, which are mandated to ensure with the compliance of the protection and promotion of human rights. And this is a major problem there, that the Kenya National Commission on Human Rights, the budget allocation is so meager that even they at the moment they're only able to manage maybe operations. But in terms of really ensuring compliance of state organs, I'm afraid they're unable to do that. So that's an area that really needs to be done at the moment. So I'll beg to stop there, and thank you very much for inviting me. Despite the challenges I have with the under the mercy of Kenya Power, I don't have a backup, and I'm at my residence, and there's a major. I think there's a lot of water has entered my fiber cable. Thank you very much.
Thank you so much, Professor Wanyama. And I must say this is actually quite an intriguing discussion, one which does not end here, but we will continue to have this discussion, because there's still much that needs to be done. So from ICJ Kenya, we want to thank each and every panelist for their time and for their insights, comments, and feedback in this discussion. I like the question, just as I had said, that was posed by Council Muranga. So what question? The so what next question? The thing is, I would want to say is that ICJ Kenya is very grateful for the support and the reception that we have received from both state actors and non-state actors, and also for the continued partnership that we have with the Kenya National Commission on Human Rights and the regional partners in reforming our criminal justice systems, to the extent that these criminal justice systems do not discriminate the poor and the vulnerable and the marginalized people in the society. As we speak today, there's an ongoing training that ICJ Kenya, in partnership with one of the task force partners, are conducting specifically for the city inspectorate offices to create awareness on the guidelines on the decriminalization and reclassification of petty offenses in Africa, and furthermore create awareness on the decision that was rendered by the African court. Ladies and gentlemen, it is without doubt that there has been progress that has been made with respect to reforming our criminal justice systems, but we have to agree that there's still more that needs to be done. With that in mind, I would like to close this panel and remind our panelists that they can find more information about the Petty Offences Campaign by logging on into the ICJ Kenya website, or also the Petty Offences website, which is www.pettyoffences.org. There's actually a lot of information on what other countries are doing with regards to decriminalizing petty offences in their respective countries. Thank you once again for your time. Thank you once again to the participants for your active participation. And thank you so much to the ICJ Kenya team for your support in ensuring that this webinar is a success. I wish you a lovely day. Goodbye from us.
Bye-bye.